Hearing in the matter of an application by Geraldine Finucane for judicial review.
My ladies, my lords, I appear in Gardaí on behalf of the appellant in this matter, Mr. James Eady, and Mr. Auckland, here on behalf of the respondent.
Do make sure that you speak up.
Yes.
Those microphones are for transmission purposes rather than for greater audibility. Mm-hmm. And the people at the back of the court won't be able to hear you unless you make yourself heard. Obliged.
We'll ask you a few provocative questions, Mr. MacDonald, and from experience, I know that that will increase the volume.
Ho, ho, ho. We're grateful to the court for granting leave to appeal in this case. It's an important case, and I know that you may have been told that before, so let me explain in just a few moments why we say it's important. This case is not just about Mrs. Finucane's right to have an inquiry into the murder of her husband. This case is about the role and responsibility of the judicial branch of the state in the face of an attack by the executive branch on the Constitution and on the legal system in particular. The available evidence suggests that the executive agencies of the state responsible for law and order devised and operated a policy of systematic extrajudicial execution that was as cynical and sinister as can be imagined. Loyalist terrorist organisations were infiltrated, resourced, and manipulated in order to murder individuals identified by the army and the police as suitable for assassination. In other words, state-sponsored terrorism. Murder by proxy, whereby the army and the police engaged in terrorism through the agency of loyalist paramilitary serial killers. The sort of thing that we used to associate with Latin American military dictatorships of the era, not with a liberal democracy founded on the rule of law. Now, we're not talking about a few rogue soldiers or police officers in the lower ranks in isolated cases. One official assessment was that something like 85% of the UDA's intelligence was drawn from security force records. Sir Desmond de Silva, in his documentary review of this case, put it in an arresting way in his report at paragraph 11.53, electronic page 1647. I have no doubt that most UDA targeting and attacks during the late 1980s could be traced back to initial security force leaks, though that is not to say that loyalists did not occasionally carry out spontaneous killings during this period.
I'm sorry, which page was this?
It's paragraph 1153 of the report. It's page, in the hard copy volumes, is appendix 5, page 1647. And it's MS page 1967. Sorry, I gave the hard copy number in the first place.
1967.
But just think about what that means. That loyalists occasionally killed people off their own bat, but mostly they killed in response to the promptings and intelligence provided by the army and the police. Now, the particular unit that this case is concerned with was a dedicated unit set up by the army hierarchy. It was called the Force Research Unit, under the command of a Colonel J. They operated their policy on an industrial scale for years. They ran a number of agents in loyalist organisations, including in particular Bran Nelson, who was infiltrated into the UDA and became their intelligence officer, supplied and handled by the UDA, by the FRU, the Force Research Unit. This was a man, I should say, who had, at the time he was recruited, a record for, among other things, abducting a partially sighted Catholic man and torturing him by electrocuting him and then setting fire to him. This is the kind of person who was being used by the Force Research Unit during this period. And under the covert guidance of the Force Research Unit, loyalists were encouraged to target Republican activists, as they were referred to, which could have included people who were believed to be involved in Republican paramilitary groups, or people who are involved in provisional Sinn Féin, or others. Apart from being self-evidently unconstitutional, this policy involved constituted a direct attack on the legal system, because the criteria for identifying targets were widened to include lawyers who appeared in court to represent those identified as Republican activists. The police, the army, and the security service, MI5, were all implicated in a policy that entailed identifying lawyers with their clients and legitimising them as targets for assassination. The implications for the operation of the legal system are obvious. The security service was engaged in so-called propaganda initiatives that involved fanning rumours and speculation in the loyalist community, linking Pat Finucane to the IRA. There was no truth in this whatsoever. At the inquest into his death, Detective Superintendent Alan Simpson said, and I'm now referring to Appendix 2, page 311, electronic copy 616, about halfway down the page. The police refute the claim that Mr. Finucane was a member of PIRA. He was just another law-abiding citizen going about his professional duties in a professional manner. He was well known both inside and outside the legal profession. He was regarded in police circles as very professional, and he discharged his duties with vigour and professionalism. Now, this propaganda initiative, as it has been termed, was ratcheted up by the Chief Constable of the RUC in person when he briefed Mr. Douglas Hogg, Parliamentary Under-Secretary at the Home Office, on the 24th of November 1988, to the effect that there were, quotes, half a dozen or so solicitors who are effectively in the pocket of terrorists, unquote. On the 17th of January the following year, 2 months later, Mr. Hogg duly said in Parliament that there were a number of solicitors in Northern Ireland unduly sympathetic to the IRA. Less than 4 weeks later, Mr. Finucane was shot dead by the UDA. The inquest into his death was a brief formality in accordance with the law and procedure at the time. The police investigation was ineffective. The CID were kept completely in the dark about the intelligence available to Special Branch. The getaway driver, that's the driver of the car carrying the persons who carried out the murder, actually admitted his role to Special Branch sometime later to police officers. Instead of investigating him or arresting him or prosecuting him, they recruited him as a Special Branch agent. When Lord Stevens was initially appointed to investigate collusion generally, that's collusion generally between the security forces and loyalist terrorists, his investigation was obstructed at the highest levels by the Army General Officer Commanding Northern Ireland and by the Chief Constable, who both denied him access to relevant intelligence. They even denied the existence of the Force Research Unit and denied that they had any agents working in Northern Ireland or that they were handling any agents here in Northern Ireland. This obstruction, according to Lord Stevens, was, in his words, cultural in its nature and widespread within parts of the Army and the RUC. That's at electronic page 807. And there was nothing subtle about a lot of this. Someone with access to the Stevens incident room burnt it down. They set fire to it in an act which Lord Stevens believed was deliberate arson. No one was ever found responsible for it, but the files that had been collected, the evidence that had been collected, was destroyed in that fire. Fortunately, Lord Stevens had taken the precaution of keeping duplicate copies of his evidence, so I'm not suggesting that the investigation was obstructed by virtue of that fire, but it reflects the audacity with which members of either the RUC or the Army at the time were prepared to obstruct this investigation, and the levels at which this must have been authorised. Mr. Nelson himself was tipped off about plans to arrest him by the legal service, plans by the Stevens team to arrest him. And he left the country, although he was eventually arrested. Government ministers and officials tried to prevent Mr. Nelson's prosecution whenever Lord Stevens recommended this. They tried to prevent that on public interest grounds by supplying the Attorney General and the Secretary of State for Northern Ireland with misleading information. He was eventually prosecuted, but not for the murder of Mr. Finucane. Eventually, 15 years later, the government agreed to have a public inquiry following the Weston Park discussions and the Judge Corey report. But they then decided to move the goalposts by introducing new legislation that was specifically designed to deal with this case, although it's been used obviously in other inquiries. That
when you say it was specifically designed to deal with this case, were there not other reasons for introducing the inquiries?
Well, what was said in Parliament?
Yes, I mean, I'd like chapter and verse on that.
Yes, well, I'll come back to the details then in due course. But what was said was that there would have to be a new act of Parliament to create the inquiry mechanism that would allow them to have this inquiry. obviously since then, the Inquiries Act 2005, as it became, has been used for all inquiries, or all major inquiries. But that was the reason why it was introduced in the first place. We'll refer you, your leadership and your lordships to the relevant passages in due course.
Thank you.
But the relevant feature of this new legislation was that it allowed a government minister to issue a restriction notice, as it was called, to restrict attendance at the inquiry and to restrict the publication of documents. In other words, government ministers were given the power to decide what documents to disclose. The family objected to that on the grounds that this compromised the independence of any inquiry that would take place. And they were in good company. A number of judges indicated an objection to this. Lord Wolfe, who was then Lord Chief Justice, seemed to agree that this compromised the independence of any inquiry held under this Act, and the government were concerned that he wouldn't allow any judges to chair such an inquiry under this Act. The court will see that at electronic page 1364. It's hard copy, volume 4, page 1044. The family did eventually agree to an inquiry under the 2005 Act when it became clear that it wouldn't take place otherwise. And they thought they had agreed a way forward by using what's called the Baha Musa Protocol, the protocol that was used in the Baha Musa inquiry, whereby it was agreed that the chairperson of any inquiry would decide what documents should be published, not a government minister. They thought they'd agreed that. Then the government made its decision not to have an inquiry at all.
So when was that agreement? The agreement you mentioned.
The Baha Musa?
Yes.
Well, the Baha Musa Protocol was devised for the purpose of the Baha Musa inquiry, which was
No, I think my lord is
before
asking, when did the family agree
to the 2005 inquiry on Baha Musa basis?
Yeah.
Yes, well, it was certainly before. I'll get the exact date, but it was it was before. It was during the period of consultations between the family and the Secretary of State before the decision was made in October. Well, actually, May.
Now, I was just looking at the very full statement of facts we've got, which is very helpful, but I don't think that was in it.
Yes.
But come back to it when it's
Yes.
convenient.
So, despite the evidence, the extensive evidence of gross misconduct, abuse of power, and criminality, including murder and perverting the course of justice, literally no one in authority has been held accountable to any degree for any of this. The only person to be convicted in relation to this murder was the driver of the getaway car, the person who had made an admission to police officers years earlier. But it wasn't because of the police investigation that he was prosecuted, it was because a journalist, John Ware, secretly recorded another admission by him in relation to the matter. Nelson was never prosecuted for this murder. Colonel Jay, the head of the commander of the Force Research Unit, misled the court about Nelson's role, at least according to the senior civil servant Anthony Langdon and according to Judge Corley.
He gave evidence when Brian Nelson pleaded guilty.
Yes, my lord. His evidence was characterised by Mr. Langdon and Judge Corley as positively misleading, although Sir Desmond de Silva thought it could bear a different interpretation, and it was wrong, but it didn't necessarily mislead the court in his view. far from being disciplined or prosecuted for his role in all this, Colonel J was promoted to brigadier and formally honoured. Nelson's army handler, direct army handler, has never even been questioned. She simply declined to cooperate with Lord Stevens, Mr. Stevens as he then was, and she sent a sick note to Sir Desmond de Silva when he indicated a wish to speak to her. So none of those responsible for, in the words of Sir Desmond de Silva, facilitating and furthering the murder of Pat Finucane, or for perverting the course of justice after the event, have had to ever explain themselves in public. The government's decision to conduct a paper-based review rather than a public inquiry has achieved two things. First, government ministers and officials have been insulated from further scrutiny. And secondly, the army officers, police officers, and security service officers involved in furthering and facilitating the murder of a solicitor whose only crime was to represent his clients effectively in court have all been guaranteed continued impunity. And the question for this...
Do you mean that
court,
in a legal sense, or do you mean it in a factual sense?
in a factual sense.
I thought so, yes.
The question for this court is whether that decision could ever properly be regarded as compatible with either the rule of law or with Article 2 of the Convention. The respondent has played the macro-political card. They claim that the decision involves such multi-layered and complex and difficult issues of political policy that the courts aren't competent or entitled to interfere with it. We say that this is exactly the kind of case where the court needs to interfere in a hard-edged way in discharge of its constitutional obligation to protect the rule of law and the integrity of the legal system, not to mention Mrs. Finucane's human rights, where the executive has subverted the rule of law and obstructed justice in the way it has here. They should not expect guardians of law and justice to look the other way when they decide to close down any further investigation of their misfeasance. If anxious scrutiny is required because of the nature of the case, it's no less required when the government invokes the macro-political defence. My ladies, lords, against that background, we propose to make submissions under 4 headings today. Firstly, why an inquiry was promised in the first place. Secondly, why the decision to renege on the promise wasn't justified. That's the legitimate expectation issue. Thirdly, why a public inquiry is required by Article 2. And fourthly and finally, I will then review as briefly as I can, the respondents' submissions to address any particular points that they have raised in opposition to this appeal. So first of all, why a public inquiry was promised in the first place?
Can I just clarify again on the history? We've got a chronology at the back of the agreed statement, and it looks as if, looking at that on the penultimate page, it was in February 2011 there were the discussions on the possible use of the Bahamusa protocol, as you called it.
Yes, on the 8th of February 2011.
It doesn't say that agreement was reached, but no doubt you'll refer us to that.
Oh, sorry, no, I want to make clear that it's not right to say that agreement was reached on both sides, that there should be a Bahamusa protocol. What we said was, what I said, I think, was that the family thought they had reached agreement that there would be a Bahamusa protocol available.
All right, well, anyway, there it is. And then the statement to the House is over the page October 2011, and that's basically when the decision is made to appoint the De Silva inquiry. And these proceedings are lodged in December 2011. What happened to these proceedings in the meantime then? Because was there, or does that not? I mean, I don't know whether it matters, but I just...
There was an application for discovery that occupied some considerable time, and there's some delay in dealing with that for various reasons. And eventually it got on, followed by a delay for the appeal to the Court of Appeal. But
I see. So it was taken up. It wasn't that it was delayed by agreement pending the De Silva report.
No, my lord.
No, I see. It was these proceedings started then, but they were delayed by procedural wrangles of one sort or another, which we're not concerned with. So,
yes, I doubt if it would have gone ahead before the receipt of the De Silva report, but that wasn't the reason why it was.
All right. Thank you.
Delayed. Initially, it was mainly, I think, because of discovery issues, from recollection, and then other procedural matters.
Whilst we've paused, can I just ask you for the page reference for the list of people involved, which was said to be Appendix 2 to one of the arguments, and
the persona, yes.
Couldn't find it readily.
I think we have it in hard copy.
Okay, but it's not in the electronic.
No, sorry, it was omitted. The chronology of the decision-making process was also omitted, unfortunately, and that's now, I think that's here as well. I think these were supplied to the office. I'm sorry they hadn't got as far as your leaderships and your lordships.
Thank you.
Thank you.
Thank you, Derek.
Thank you.
So why a public inquiry was promised? There was obviously pressure for an inquiry from the outset, but Stevens 3 was the first time any serious investigation was undertaken. But that, of course, was a private police investigation from which the family and the public were excluded. No more than a short overview was ever published. It's probably worth going to that overview at Appendix 2, page 491, which is electronic, page 798. There's a short introduction, and in chapter 2 an outline of the events. Chapter 3, page 501, electronic page 807. There's reference at paragraph 3.1 to the cultural and widespread obstruction. 3.4, he refers to the fact that their premises were destroyed by fire, and that he believes that was a deliberate act of arson. Then chapter 4 is the conclusion. This is at hard copy page 504, electronic page 810. Paragraph 4.6. I have uncovered enough evidence to lead me to believe that the murders of Patrick Finucane and Brian Adam Lambert could have been prevented. I also believe that the RUC investigation of Patrick Finucane's murder should have resulted in the early arrest and detection of his killers. I conclude there was collusion in both murders and the circumstances surrounding them. Collusion is evidence in many ways that this ranges from the willful failure to keep records, the absence of accountability, the withholding of intelligence and evidence, through to the extreme of agents being involved in murder. And that's it. As far as the public were concerned, as far as the family was concerned, that was the extent of the information provided about the Stevens 3 police investigation. It was then subsequently agreed at Weston Park that there would be a public inquiry if that was recommended by a judge appointed to look into the matter. And Judge Corey, a Canadian judge, was appointed in due course. His report can be found at Appendix Volume 2, page 599, electronic, page 905. I'm not sure if anyone's using the hard copy pages or whether I only need to give the electronic pages, or
You seem to have
or maybe
5
both.
computers confronting you, which is unusual.
I'll carry on giving both unless I'm told that it's just too tedious.
It's quite useful to have both, just in case later on we revert to paper copy.
Obliged, Mark.
Thank you very much.
So in the Corey report, this was a detailed report about a number of matters, including the murder of Mr. Finucane. I don't propose to spend much time on this, but if I could perhaps take the court, first of all, to paragraph 1.3 at page 605, electronic page 911. There's a reference there to the extent of the inquiry and the fact that he had been assured by state agencies that they'd furnished me with all information that might bear on the issues he's examining. So he was satisfied that the review was as comprehensive as possible. We now know from Sir Desmond de Silva that that wasn't correct, that there was new and significant information that Sir Desmond de Silva had that Judge Corey didn't. But he said at 1.9, that's electronic page 912, hard copy 606, that the inquiry was limited in its powers and its scope. It was only designed to ascertain whether there were grounds for an inquiry, not it was not meant to represent a final, definitive account.
What paragraph was that?
That was 1.9
1.9, thank you.
at hard copy 606 MS 912. At page hard copy 624, electronic page 930, paragraph 161, under the heading Targeting. He says, after Nelson's re-recruitment, there is no doubt that FR, Force Research Unit, understood that he was targeting individuals for the UDA and that was his prime function. And that Nelson, the last sentence, was running an operation against selected Republican personalities. Then paragraph 1.103. At hard copy 634, electronic, page 940, under the heading Targeting of Target O. solicitor. There's reference to targeting of another solicitor. And over the page, over the hard copy page, top of page 635, electronic page 941, it said, yet another agent confirmed this, stating they are planning to shoot 3 solicitors, Pat Finucane and then 2 others. And at 1.105 on the same page, middle of the paragraph, thus within days of Patrick Finucane's murder, there was evidence to suggest that other solicitors were also targets, yet nothing was apparently done to prevent further loss of life. Then 1.146, hard copy 647, electronic page 953. In short, the documents raised serious and perplexing questions regarding the extent to which FRU had advanced knowledge of the targeting of Patrick Finucane. The inference could certainly be drawn from them that they had advanced knowledge of the targeting. However, these questions can only satisfactorily be answered by a public inquiry. The documentary evidence certainly indicates that such an inquiry should be held. Then 1.171, hard copy 655, electronic 961. The evidence given at Nelson's trial by the former CO of FRU, together with his subsequent letter, raised troubling questions not only as to his conduct, but as to the likelihood of collusion by FRU. It reflects a pattern of conduct and an attitude that is consistent with acts of collusion taking place. Whether or not acts of collusion did take place can only be determined at a public inquiry. Certainly, this is a further basis for holding a public inquiry which may provide answers to these questions. Then 1.178, hard copy 658, electronic 964, refers to the involvement of the security service in relation to earlier planned attacks where they hadn't given any warning to Mr. Finucane, but at the end of the paragraph, in any event, they must be taken into account in considering the overall or cumulative effect of all the relevant documents. That cumulative effect leads to a conclusion that a public inquiry should be held to examine the issues raised in this case. Then 1.245, at hard copy 684, electronic 990, under documentary evidence relating to attitude, discounting FRU intelligence. Well, 245, some of the documents I have reviewed seem to reveal an unfortunate attitude that was shared by some members of the RUC Special Branch in 88 and 89. 1.246, it was the duty of Special Branch to protect all individuals, whatever their religious or political affiliation. In this, it failed. The documents indicate that in some instances, Special Branch failed to take any steps to prevent actual or planned attacks on persons targeted by loyalist terrorist groups. And over the page at 685, electronic 991, top of the page, it's therefore difficult to understand why Special Branch paid virtually no attention to his intelligence reports. Nelson consistently identified persons who were threatened, attacked, or were the subject of attempted attacks by the UDA. Then 1.256, under the heading, the association of lawyers with their clients who were provisional IRA members. Documents reveal the extent to which Special Branch believed that solicitors representing members of provisional IRA were themselves either members of the organisation or Republican sympathisers. Halfway down the paragraph, what is most striking is that Patrick Finucane is repeatedly identified as a Republican sympathiser, an extreme Republican sympathiser who represents IRA members who face terrorist charges. These descriptions permeate the file. The file records various activities that were legitimately undertaken by Patrick Finucane in his capacity as a citizen, a lawyer, and a supporter of human rights. He is implicitly criticised for taking a keen interest in the welfare of IRA prisoners during the hunger strikes and for being a member of organisations such as the Northern Ireland Civil Rights Association. The attitude of Special Branch toward the work of solicitors in general is also evident in the briefing given to MP Douglas Hogg. And then 1.258 is reference to the information given to Mr Hogg to the effect that there were half a dozen or so solicitors effectively in the pockets of terrorists, and that such solicitors were defending the organisation rather than the individual. And 1.269 at page hard copy 692, electronic page 998. Paragraph 1.269. I have reviewed a document which would appear to lend strong support to the allegation that RUC Special Branch and Force Research Unit consciously set out to withhold pertinent information from the Stevens inquiries. It sets out the minutes of various meetings attended by senior officials, including the former General Officer Commanding NI. This document confirms that the GOC-NI had discussed the Stevens inquiry with the Chief Constable of the RUC before the inquiry team even arrived in the province. The document states that the Chief Constable had decided that the Stevens inquiry would have no access to intelligence documents or information, nor the units supplying them. And there's further discussion of that. And then in paragraph 1.270 on the same page, the willful concealment of pertinent evidence and the failure to cooperate with the Stevens inquiry can be seen as further evidence of the unfortunate attitude that then persisted within RUC Special Branch and Force Research Unit, namely, that they were not bound by the law and were above and beyond its reach. An unfortunate attitude, I would respectfully suggest, that has been entirely borne out by subsequent events, and in particular by the government's current decision not to have an inquiry into this very matter. In other words, the police and the army were entirely right when they were saying they are above the law. They can literally get away with murder, not once or twice, but on an industrial scale over a period of literally years. And Judge Corey said at the end of that paragraph, ultimately, the relevance and significance of this matter should be left for the consideration of those who may be called upon to preside at a public inquiry. Then 1.293, at hard copy 703, page, electronic page 1009, some of the acts summarised above are in and of themselves capable of constituting acts of collusion. Further, the documents and statements I have referred to in this review have a cumulative effect. Considered together, they clearly indicate to me that there is strong evidence that collusive acts were committed by the Army, Force Research Unit, the RUC Special Branch and the Security Service. I am satisfied that there is a need for a public inquiry. And then there's some discussion on the next page about the basic requirements of a public inquiry, including an independent commissioner, full powers to subpoena witnesses and own counsel held in public, and the ability to engage investigators. Now, the subsequent history is recited in some detail in the papers. I don't really have time to examine that. It's in the written submissions. In brief, the inquiry, which was announced by the government in 2004, was delayed until, first of all, the getaway driver could be prosecuted, and then after that, until the government could put in place legislation to deal with the so-called sensitive evidence in the case, in the form of the 2005 Inquiries Act. In the meantime, all the other inquiries recommended by Judge Corey went ahead, and throughout this entire period, it was recognised and repeated by government at the highest levels that an inquiry was required in the circumstances of this case, but it never happened. So that brings us on to the second broad issue here, why the decision to renege on that, the promise to have an inquiry, isn't justified and wasn't justified in common law terms. Now, the first thing to be observed here is that despite the onus being on the respondent to satisfy the court that there were particular public interest considerations that were sufficiently compelling to override the requirement to comply with the promise to have an inquiry, the respondent hasn't sworn an affidavit in this case to explain, first of all, what exactly those considerations were in his mind, and secondly, why...
When you say the respondent, who do you mean?
The Secretary of State.
for Northern
Present
Ireland.
Secretary of State.
Yes. Oh, well, the Secretary of State in the office. It's not the same Secretary of State as made the decision. It was Mr. Owen Patterson who was
Yeah, but I
Secretary.
mean, it's rather important to identify what individual you're saying.
Yes, well,
Swear.
Mr. Patterson, who was Secretary of State at the time the decision was made and at the time the proceedings were issued, and at the time affidavits were sworn by officials seeking to explain what must have been the reasons for the Secretary of State's decision.
Thank you.
So the Secretary of State responsible for this decision hasn't identified the considerations that he took into account, and he hasn't said why exactly those particular considerations trumped the need to have an inquiry. Instead, senior officials, have given evidence by affidavit of what they did and what they recorded as the reasons for the decision. Now, my ladies, my lords, we recognise that it may be conventional practice for courts to accept indirect hearsay evidence of that kind in judicial reviews, but in our submission it's not appropriate or acceptable in this case, in circumstances where, first of all, there's an onus on the respondent in person, not only to identify which public interest factors are said to justify the decision, but to explain how and why those persons, the decision makers, judged those factors to outweigh the need to have an inquiry. And secondly, where there's a requirement for the court to subject the decision to anxious scrutiny. And thirdly, where the requirements of the duty of candour must be enhanced for those two particular reasons. In our submission, those requirements cannot be met by officials exhibiting their own briefing submissions to ministers and reciting the outcome of the minister's deliberations. Because what's important is the reasoning of the decision maker himself or herself, as the case may be. And in this context, we would refer to what one of the officials advised this Secretary of State. It's in the Appendix 4, page 1187, at electronic page 1507. In paragraph 18 at the bottom of that page, where this official should pay tribute to this official for the impressive and extensive submission that he provided to the minister, setting out all the relevant public interest factors and the reasons for and against an inquiry. But what he said at paragraph 18 was, Each public interest factor is dealt with in turn below. Against each factor, a detailed overview of the arguments in favour of an inquiry and against an inquiry is provided. It is for you, as Secretary of State, to decide on the relative weighting to accord to each factor, though you must consider each factor and explicitly take into account the factor relating to the previous commitment made. Then the potential policy options were assessed against all the different public interest factors that had been identified by the Secretary of State.
Who was this official? Who was the official?
This is Mr. Threlfall. Brendan Threlfall, that appears at hard copy 1175, electronic page 1495. He was a senior official in Constitutional Policy and Liaison Division, Northern Ireland Office. He was advising the Secretary of State, and he did provide impressive briefings to the Secretary of State in which he examined all the issues. The point is that it's not really what he was thinking during this process, it's what the Secretary of State was thinking during this process and what decisions he came to and why he came to those decisions. But by not swearing an affidavit, of course, ministers were completely shielded from this kind of direct scrutiny and, of course, shielded from cross-examination because they hadn't sworn affidavits. And as Lord Kerr will remember from the Williamson case in Northern Ireland, if a Secretary of State hasn't sworn an affidavit, he cannot be asked to come to court to be cross-examined by the appellant. So a failure to provide affidavit evidence provides that protection to a Secretary of State.
But your point here is that the Secretary of State was being told by Mr. Threlfall he had to make a decision weighing up the various factors and applying the scrutiny that was commended by Mr. Threlfall. So his statement, that is Mr. Threlfall's statement, cannot by definition act as a substitute for the reasoning and assessment of the Secretary of State.
Yes, my Lord. And when officials such as Mr. Larmer from the NIO record an affidavit, or swear an affidavit in which they set out the process and identify the factors that have been identified by other officials, that does not amount to evidence that the Secretary of State himself actually identified those particular factors as the relevant factors, or why he identified particular factors as so compelling that they had to override the promise that had been made. And in fact, as the court will say in due course, there are gaps in the evidence where there's a failure, complete failure to explain the reasoning of the Secretary of State himself. But in our submission in broad terms, this entire process, this consultation process, decision-making process, was a sham.
I find that an odd word. I notice it's used, but I've been reading this report. It's not the sort of thing that looks like a sham. I mean, you may say that we haven't got the sort of last step, what the minister actually did with it, but it doesn't mean it was a sham.
It was far from a sham in the minds of the officials. I want to make it absolutely clear that we have no criticism of the officials here. They conducted a process in good faith, no doubt, in which they set out in extenso all the issues that had to be addressed. But it was a sham in our respectful submission as far as the Secretary of State was concerned. Because, well, first of all, we have the evidence that his view was that there should be no more open-ended inquiries, full stop. But when he purported to apply the criteria, the public interest factors that were identified by officials as being the relevant factors, he came to a conclusion which went out the window as soon as the Prime Minister intervened for reasons that really have no connection with the public interest factors. We really only have time to identify the highlights in this process. We've dealt with them in some detail in the written submission. Specifically, in our part 2 of our written case, from paragraph 18 onwards, we say that the decision to have no inquiry was a foregone conclusion because the government's policy was no more open-ended inquiries. But they recognised, because they had legal advice, no doubt reliable, good legal advice, that they had to go through a proper process. And there are notes in the papers to the effect that the officials were reminding ministers that they had to be seen to go through this proper process in order to justify reneging on the promise to have an inquiry. And really, for present purposes, of oral submissions, we would like to refer in particular to one piece of evidence indicating the approach we say adopted by the ministers. There's a letter from a Mr. Fletcher, which can be found in Appendix 4, page 992, electronic page 1312. Now, this is a letter from Tom Fletcher, the 4th of November 2010. This is at the very outset of the so-called decision-making process. It's addressed to the Prime Minister. Mr. Fletcher was the Prime Minister's advisor on Northern Ireland and foreign policy, as far as I understand. I'll be corrected if I'm wrong about that. And it's a briefing paper to the Prime Minister. It's really a covering note, covering a letter that the then Secretary of State, Owen Patterson, was sending to the Prime Minister, explaining the decision-making process and how they'd have to look at all these public interest factors before they could decide whether or not to have an inquiry. And what Mr. Fletcher says is, it's probably too soon for you to make a formal intervention on this issue. This was at a discussion that was going to take place between the Prime Minister and the Secretary of State. Better to allow colleagues to chip in with views, and ideally for Owen to come forward with the conclusion that a further inquiry would be inappropriate. This is at the very beginning of this process where the Secretary of State had an open mind and he would eventually decide whether the public interest factors pointed towards an inquiry or no inquiry. But we need to think carefully with Owen about handling. And then there are a list of bullet points of things or people to be handled. Coalition dynamics, coalition being in place at the time, and the Liberal Democrats having indicated support for the inquiry. Cabinet discussion, Adams, McGuinness, the Irish, the Americans. In other words, we have to think about handling all the people who want an inquiry. There's no reference to handling people who don't want an inquiry, because it was known by all the people who received this email in our respectful submission that there was going to be no inquiry. But we have to start thinking about, well, first of all, how that's indicated. Ideally, Owen will indicate that it's not appropriate, but in any event, we're going to have to decide how to handle all the people who will be outraged whenever it's decided there's going to be no inquiry. There's really no other interpretation that can be put upon this letter. And it can't be just said that, well, this is an official speaking and this has nothing to do with the Prime Minister. This was being said to the Prime Minister by somebody who obviously knew the Prime Minister's mind and felt confident enough that there was obviously not going to be an inquiry, that he could start talking about the fallout after the event. And it's that political fallout which provides the so-called macro-political feature of this decision. There's nothing macro-political about the decision itself, whether an inquiry is necessary. The macro-political element was handling the political fallout, the consequences of the decision, because there would be outrage and uproar with Adams, McGuinness, the Irish government, the American government, or Americans generally, and possibly with the Liberal Democrats in the coalition. And then there's a follow-up to that letter at hard copy page 1000, electronic page 1320. This is a letter from, say, Mr. Fletcher to an official in the NIO. Thank you for your Secretary of State's letter. Prime Minister agreed to the course of action set out in the letter, which was we'll have this elaborate, as they called it, process of consultation and evaluation of public interest factors. Without prejudice to the outcome of his deliberations, the Prime Minister asked for further thought and other ways of dealing with this case. For example, the HET or a non-statutory inquiry. In other words, something other than an inquiry. The Prime Minister...
HET being the Historic
Inquiries Team, that division of the police. The Prime Minister agreed that the timing should not be affected by consideration of inward-outward business. The Prime Minister asked for further advice on handling. So, just in case anybody might think the Prime Minister wasn't involved in this, the official was on a frolic of his own, talking about the need to handle the political fallout when they decide not to have an inquiry. The Prime Minister was saying, you better give me more advice on handling the debate, not in Northern Ireland, but in the US and Ireland. In other words, where they were going to be outraged by the decision not to have an inquiry. And then this is copied to all the people who might be interested in it, including apparently the embassies in Dublin and Washington. And when the Secretary of State purported to apply his 6 public interest factors, what he did was to come up with these 2 options that are mentioned here, a limited inquiry and no inquiry. They were presented to the Prime Minister, and it was the Prime Minister who apparently suggested a way to sweeten the pill of having no inquiry. That was the option of maybe some kind of non-statutory inquiry or review, and that was done without any kind of reference to the 6 factors, but only with a reference to the government's own policy. And that can be seen at hard copy Appendix 4, page 1012. Electronic page 1332. This is a letter dated the 6th of May 2011. This is now very close to the end of the process, close to the decision itself. So the Prime Minister, this is a letter from Prime Minister's personal private secretary, Simon King, to the Secretary of State's private secretary. Prime Minister met with the Secretary of State and the Minister of State for Northern Ireland yesterday to discuss the Finucane case. Jonathan Kane attended. And actually, just before I look at this, maybe worth referring to what Jonathan Kane was saying at the time. This is it's in the same volume, Appendix 4, page 1270, electronic page 1590. But sorry for flitting between one and the other, just to see this in context, what the sort of things that were going through the decision makers' minds here. Electronic page 1590. This is a note from Mr. Kane dated the 4th of May, and it's addressed to State Chief of Staff Political. This I understand to be in the Prime Minister's office, although I'll be corrected if that's wrong. I thought it might be helpful to submit some purely political points in respect of a possible statutory inquiry into the death of Patrick Finucane. Owen and I believe that not proceeding with an inquiry would cause few problems within the Conservative Party. Taking a decision to hold an inquiry, however, would open us up to potential attack from elements of the Conservative Party and the right-wing press such as the Mail and the Telegraph. The main criticisms are likely to be as follows. We've reneged on our election manifesto commitment to no more costly and open-ended inquiries and no hierarchy of investigations into the past. And then there's some further discussion of this, including over the page the reference to the Liberal Democrats apparently supporting an inquiry. Now, against that background, looking at the 1271, the conclusion. Any decision on Finucane will ultimately have to be taken based on a whole range of considerations that go beyond the political aspects discussed in this note. I did, however, think that they may merit some discussion. So then, turning to the letter written after the meeting between the Prime Minister and the Secretary of State, page hard copy 1012, electronic 1332. Prime Minister met with the Secretary of State. Secretary of State updated the Prime Minister in the background. The Prime Minister was grateful for this update. He understood that this was a difficult case and that there was pressure for public inquiry. However, given the government's policy on inquiries, he asked that further consideration be given to, before a final decision is made, to the option of making a statement saying what we knew about what happened, apologising for actions which we thought were wrong, although they didn't actually know what exactly was wrong, and possibly also asking an independent person to carry out a rapid examination of the details of the case, but stopping short of a full public inquiry. So that's the qualifying phrase there is, given the government's policy on public inquiries, that's what determines the approach, not any delicate weighing in the balance of all the 6 public interest factors identified by the Secretary of State, or more accurately by the officials of the Secretary of State. There's then a gap in the evidence. The next we hear is that by the time of the ministerial meeting on the 11th of July 2011, when the decision was taken, apparently, the Secretary of State had, and this appears from volume 1, page 221, electronic 517, it's probably worth looking at it. Electronic page 517, paragraph 57. This is the affidavit of Mr. Larmer from the NIO, from the Secretary of State's Department. He says the meeting of ministers from interested departments was arranged to take place on the 11th of July 2011. Other ministers invited to attend were the Prime Minister, Deputy Prime Minister, Home Secretary, Secretary of State for Defence, Secretary of State for Justice, Attorney General, and the Chief Secretary of the Treasury. By that time, the Secretary of State had made known to officials that his preferred option was not to hold a public inquiry, but to carry out an independent review of the circumstances of the murder of Patrick Finucane based upon the existing materials, with a view to publishing a full account. Now, left to his own devices, the Secretary of State, when purporting to apply these 6 public interest factors, had come to the conclusion that there really weren't any options here other than a limited 2005 Act inquiry or no inquiry at all. Full stop. The Prime Minister intervenes and says, given our policy, you need to think about maybe something else, some other kind of rapid examination of the documents. And lo and behold, unsurprisingly, the Secretary of State has now come to the conclusion that his preferred option is one that they'd never thought of before, but it happens to be the Prime Minister's. No justification for this is advanced. There's no evidence from, obviously, the Secretary of State. There isn't even evidence from an official who might be said to somehow know the Secretary of State's mind. There's no evidence from an official of any meeting at which this was discussed. No evidence of any minute from the Secretary of State explaining his reasoning. Don't want to be tedious about this. I'll summarise it by saying no evidence whatsoever explaining either the factors, the public interest factors identified by the Secretary of State, or 2, the reasons why those public interest factors justified reneging on this solemn commitment to have a public inquiry. It's completely blank. And if the court is engaging in any kind of anxious scrutiny or even limited scrutiny of this, it will find no evidence. And the courts below should have found no evidence that the Secretary of State was justified in coming to the conclusion that he did. By not providing evidence of any kind, even through an official, the respondent has effectively denied the court the opportunity to engage in close scrutiny of this process. Whatever about the reams and reams of official submissions and briefing papers that talk about the public interest factors. So the final decision was made at this ministerial meeting on the 11th of July 2011, and it's recorded in a letter that the court will find at Appendix 4, page hard copy 1062, electronic page 1382. This is a curious letter, dated the 14th of July 2011. And again, we're relying on an official to record what was said, and by implication, what must have been thought by the decision makers here. The second, and of course the primary feature of this, is that there isn't any express reference to the 6 public interest factors that were announced with great ceremony at the start of the process as being the factors against which the decision would be judged and the decision would be made. The assessment would be made and the decision arrived at. In the second paragraph, the Prime Minister opened the meeting by noting that the supporting papers set out fully the complexities and difficulties of the case and the options for proceeding. And just in passing, if I would note that there's no reference here either to the gravity of this case, which I'm going to come to again shortly. The gravity of this case in the assessment of the decision makers, or the importance of the original commitment to have an inquiry. It's about the complexities and difficulties in general sense. Then there's this sentence, which jumps out of the page. The primary objective must be to find the truth, which of course is a noble and worthy objective if it's actually seriously intended and seriously meant. What follows makes it clear that this couldn't have been seriously entertained as being the primary objective. There were strong reasons to conclude that the public interest in meeting this objective would be better served by a process other than a potentially lengthy, costly and procedurally difficult public inquiry which may ultimately prove unworkable given the sorts of national security issues that which it would be required to cover. The Prime Minister's preferred route was, therefore, this is given that the primary objective is to find the truth, to ask an independent person to carry out a paper-based review of all existing material relating to the case, including that held by government departments, with a view to considering what more information could be made public. And then, next paragraph, ministers agreed with this assessment, broadly supportive. In discussion, the following points were made. And again, here you might expect to find some discussion of the gravity of the case, the importance of the original commitment, the need for an inquiry, and how these the 6 public interest factors could outweigh, in some compelling way, the need for an inquiry. First difficulty is that one of the key difficulties with the proposal for the statutory inquiry, as inherited from the previous government, would be securing a suitable chair. There was no guarantee that the Lord Chief Justice would be willing to release a judge to do this, given the previous judicial objections to restriction notices under the 2005 legislation. These are the objections to the fact that these inquiries can't be completely independent. Their independence is going to be compromised by the fact that a minister in the government that's being investigated to some extent, can decide what documents to disclose. And that's not about the public interest. That's about the acceptability to judges, senior judges of the Inquiries Act. Secondly, however, if the proposal did not secure widespread support, particularly from the Finucane family, there were a number of risks. Now, here we're talking not again about public interest factors, but about risks, political fallout, the sort of things that are going to have to be handled, as Mr. Fletcher identified at the start of the process when they made the decision not to have an inquiry. The most obvious one was judicial challenge, and an unpredictable factor could be the response of the Attorney General for Northern Ireland, who had the power to initiate an inquest. And the next sentence is an interesting sentence. In that scenario, the government could fall back on a statutory inquiry. This is not about statutory inquiries being bad in the public interest or contrary to the public interest, because that's what they would fall back on. If the Attorney General blindsided them and decided to have an inquest where they couldn't have the same control over the disclosure of documents, because, as the court knows, it would be the coroner who would decide the public interest and the balance between the public interest, the different public interests in play, including the importance of non-disclosure of sensitive material. So they were prepared to fall back on a statutory inquiry if need be. So very little evidence here of compelling public interest reasons for not having an inquiry. It was going to be perfectly suitable and convenient if it avoided the dire consequences of having an inquest, which would allow a legal officer, a judicial officer, to control the process as opposed to a government minister. So this option remained on the table even after an administrative review had been tried. And this is also important, that the phrases that are used, the epithets that are used here, reflect the government's own assessment of what was being done here, what was being provided. It was Corey 2, an administrative review, a documentary review, not any kind of process where the truth is going to be dug up and revealed to the public. And the next one is just about the modalities of a review. A documentary review would have to have the appearance of credibility, would have to have a credible figure to do it. But of course, as it says in the middle of the paragraph, the reviewer could not have powers of compulsion, because then it would take it towards a statutory judicial inquiry. And then summing up in the last paragraph on that page, the Prime Minister said it was clear that the review proposal had the support of ministers, although their risks were clearly understood. This is all about political risks and the risk that maybe an inquest would pop up, and they would then have to have an inquiry in any event in order to prevent anybody apart from government ministers having the final say on what documents were disclosed. And it goes on then to say, middle of that paragraph, we'd have to look at, the review would be looking at how and why things had gone wrong, not whether. And the bottom of the page, the Prime Minister would be prepared to meet Mrs. Finucane to explain why he thought the process being suggested was the best way to meet her understandable demand to know what had happened to her husband. Now, if it had been accepted that this really was, well, if it's accepted by this court, that this really was the primary objective of the Prime Minister and the Secretary of State, then the court should also find that the Secretary of State and the Prime Minister completely misapprehended the facts. Misapprehended the facts so completely as to vitiate the decision. Because Judge Corey, first of all, had expressly said that the nature and extent of collusion could only be determined by a public inquiry. Their own officials had advised them in terms that there are no easy answers in the files, quote unquote, and there are many unanswered questions, quote unquote. So just for your ladyship's and your lordships, note that's at Appendix 4, page hard copy 1038, or electronic page 1358. That's in a Cabinet Office document. And there are other examples of this that we've referred to in our written submissions where it was known by everybody that the answers aren't in the papers. So a review of the papers wasn't going to provide the answers. And it's interesting just to look at the speaking note that had been prepared for the Secretary of State prior, for the purpose of this ministerial meeting. It's at Appendix 4, hard copy, page 1300, electronic, page 1620.
You say that they knew that a review of the papers wouldn't provide the answers.
Yes.
Was there a difference between the papers that were before Lord Stevens, Judge Corey, and the papers that it was suggested would be before the proposed independent review?
Well, it was understood, I'm not sure the evidence of this is entirely clear, but I think in fairness to the government, it must have been understood that all the papers had been available, all the relevant papers had been available to Judge Corey. At least that's what Judge Corey thought.
Yeah.
And he said expressly, as I've mentioned in the review that I undertook earlier, he thought he had been given everything by the government. The government presumably thought that the government decision makers in this case can be assumed for present purposes to have believed that everything had been given. But of course we now know that everything hadn't been given, because Sir Desmond de Silva subsequently, when he carried out his review, said he had been given, quotes, new and significant information, unquotes. That has subsequently been examined by the police, and that's the subject of some the additional evidence.
Yes.
And I'll come to that in due course. We don't actually know what the new and significant information is, other than, according to the police, it relates to the propaganda initiatives of the security service, which the police have concluded don't indicate complicity in the murder. But I think reasonably it can be inferred that it was believed that the papers that were going to be reviewed would have been the papers that had previously been reviewed by Judge Corey, because everything had apparently been given to Judge Corey.
Thank you.
So this is the, starts at page, hard copy 1298, electronic 1618. It's a speaking note provided by Mr. Brendan Threlfall of the Security and Legacy Group in the NIO to the Secretary of State for the purpose of the meeting, because it was expected that the Secretary of State would lead the discussion. In fact, he didn't get a chance to lead the discussion according to the documents. The Prime Minister stepped in and indicated his preference. But in this speaking note, at page 1300, electronic page 1620, there's some bullet points. In particular, in the lower half of the page, the risks to the government of being seen to cover up state-sponsored collusion is extremely high. Even if we could draft a generalised statement about what happened, it would be extremely limited at this stage, given that we cannot answer key questions about what the state knew in advance. And then there's a complete non sequitur, skipping a bullet point. So on balance, I favour, and this is what the Secretary of State was supposed to be saying to the other ministers, so on balance, I favour the option of asking an independent figure to use the material collated by the Stevens investigation to produce a full public account of any state involvement, which they knew they couldn't provide. This would enable the government to be clear that we did not want a costly and open-ended inquiry, that we supported the full truth emerging. Now that's political doublespeak of the worst kind, in my respectful submission. It was being suggested as a way to approach this matter with the ministers for the purpose of this decision. And it was being said, we can't actually answer the key questions, but we'll devise a scheme which will allow the full truth to emerge. It was just impossible. And nor, as we say, was there any attempt to address the gravity of this case, or therefore the importance of having an inquiry, quite apart from the existence of the promise. Even though the respective officials, that is the officials in the NIO for the Secretary of State and the officials in the Cabinet Office for the Prime Minister, had left them in no doubt about the gravity of this case and therefore the importance of having a public inquiry. I'm going to take the court through a very brief review of some of the places where the importance of this is emphasised in the papers. First of all, Appendix 4, page 1178. Top of the, this is MS Electronic 1498. The death of Patrick Finucane is one of the highest profile legacy cases and the one in which the pressure for a public inquiry has always been greatest. That was for Mr. Threlfall to the Secretary of State. Same Appendix 990, Electronic 1310. This is from Kieran Martin, a director of a department in the Cabinet Office, to Tom Fletcher, the NI and Foreign Policy Advisor for the Prime Minister, referring to the Prime Minister's meeting with Owen Paterson, the Patrick Finucane case. Long letters being received, refers to the iconic residence in Northern nationalism, the Republic of Ireland and Irish America. It's in the middle of this paragraph where there's reference to this being, this process, the decision-making process being elaborate. It may seem elaborate, but it's viewed as legally essential. And to that end, it's imperative that the government is seen to have given proper consideration to all the relevant factors. But in middle of paragraph 3 is where he deals with the gravity of the case. However, Finucane is only the most difficult. If we're trying to get a sense of how important this is and how important it was seen by officials within the government and ought to have been seen by the decision makers in terms of public concern, the importance of having a public inquiry under the Inquiries Act, what they're being told is it's the most difficult, the top of the tree, the most difficult of a number of difficult legacy cases about the actions of state forces that NIO has to grapple with.
What did they mean by difficult?
Certainly.
What do you think they meant by difficult?
Well, obviously that's open to interpretation. One of the...
Difficult to handle or
It was-
difficult to determine? Or...
No, they go on to say that one of the problems is the one-sided nature of the concerns, that it might be looking one-sided by the unionist eyes. I mean, that's what they're saying.
Difficult to handle it. Mm.
Yeah, but difficult to handle, I'm not sure. You know, I mean, there one is getting
No,
to what
I think the
might be
difficulty...
macro-political.
Well, there are different aspects of the difficulty, but
Yes, I mean, it's
they were
obvious.
saying...
I mean, what's quite clear, it doesn't need... There were a whole lot of interacting issues which they were trying to grapple with, but some of them were, you would accept, were macro-political in the sense...
Well, there is reference in the papers to dealing with the unionists in relation to this, but it's made clear expressly that they were saying, actually, there won't be that much noise from the unionists about this. The difficulty really relates to the scale of what was going on, and also, in one sense, the difficulty dealing with the so-called sensitive issues arising from this, because it involved a disclosure of information concerning the way agents were being handled at the time.
But I'm just wondering how helpful it is going back over all these. I mean, we've got this very full report, as you accept, by Mr. Threlfall, which sets out what the officials thought were the considerations, and we then get the report of the crucial meeting,
Yes.
where it's clear that the Prime Minister was taking a view about inquiries. I mean, a policy before about having long and expensive inquiries, and to look for some other solution.
What I'm doing
So
here...
we have to form our view on that. But I mean, inevitably in a case like this, one can dig around in the papers and find all sorts of people saying all sorts of different things.
No.
But surely what really matters for your purpose is what actually happened at the crucial meeting when the decision was made.
It does.
Yeah.
But what I'm doing here is indicating, bearing in mind that there's no reference at that crucial meeting to the importance of this case.
Well, I mean, come off it. It was quite, having a meeting at that level clearly indicates that everyone understood the importance, and anyone who had read the papers would have, would have been mad if they didn't realise it was a very important case, whatever sense. That's not the issue.
Well, important in different contexts, my lord, because the problem, what was really difficult for this government was handling the political fallout. This was what this was all.
Well, that was difficult, but I mean, I'm not sort of wanting to have an argument with them. All I'm saying is actually your case is rather simpler than you seem to be suggesting, because we have very clear material as what in the lead up to the decision, and we have pretty clear material of what happened at the relevant time. And I'm just wondering why one needs to sort of complicate it by digging around in papers which inevitably are very, very extensive.
Well, I'm trying to make it simpler, my lord, obviously not very successfully, by isolating some 3 or 4 more examples of advice given to ministers to indicate how really grave this matter was, and which make it therefore more difficult to understand how it wasn't assessed as being so gravely important that an inquiry had to take place, rather than the decision, well, actually, we'll just have some sort of paper review to reveal the truth in circumstances where we've been told that actually the truth isn't necessarily in the papers. I'll probably take about 5 minutes on more in this particular passage of the submissions, my lord. It's really, for the convenience of the court. I know that we have identified a lot of this in the mass of papers that have been provided to the court, but I'm trying to make it easier for the court to identify where it was indicated that this was not just a bad case, but as bad as it gets, in the words of officials. And that must have a consequence in our submission. So at Appendix 4, perhaps I'll just identify some of the page references if the courts can, regarding this as a tedious exercise. At Appendix 4, page 1008, that's electronic page 1328, in a note from Mr. King to the Prime Minister. This issue has iconic status as the last great legacy issue on the nationalist side.
So could I have the MS page again? I'm so sorry.
Sorry, my lord. 1328.
1328, thank you.
And then at Appendix 4, page 1034, MS 1354, the court will find another cabinet paper in which it said that this was the last of the most significant unresolved, which we emphasise, unresolved legacy cases from the Troubles. And, well, perhaps I could take the court to this one at same Appendix 4, page 1054, MS 1374. This is a detailed cabinet paper prepared by Mr. Kieran Martin for the Prime Minister. Brief sent on the 8th of July 2011 for the crucial ministerial meeting at which the decision was made. The last main paragraph at 1054 MS 1374. In terms of allegations of British state collusion, if the court has that.
Yes.
with loyalist
That's after a
paramilitaries.
redaction.
After the
what's
redaction,
clearly a
yes.
redaction, yes.
Yes. This is the big one. This is their terminology. And they then refer to what Douglas Hogg had said as a Home Office Minister, about 5 or 6 lines from the bottom. Whilst we know of no evidence of direction or advance knowledge of the murder by ministers, security chiefs or officials, exhaustive previous examinations have laid bare some very uncomfortable truths. Paid state agents were directly involved in the killing, including the only man ever convicted of involvement in it. Lord Stephen's conclusions paint a picture of a system of agent running by the RUC Special Branch and the Army's Force Research Unit that was out of control, whatever the hugely difficult context of the Troubles. There's plenty of material in the public domain to this effect. Some of the evidence available, only internally, could be read to suggest that within government, at high level, this systematic problem with loyalist agents was known, but nothing was done about it. And of course, it's the responsibility of government that's
I mean, this is a note directed to the Prime Minister.
Yes, Lord.
Well, I mean, unless he completely ignored it, how can you say that the importance wasn't appreciated? This is the big one. That's what he's being told.
Yes. Well, it shouldn't have been the case.
He forgot that when he came to
It
make
shouldn't have been the case that it was not appreciated. But it must have been the case that it was not appreciated if in the letter recording the decision-making at the ministerial meeting and the list of bullet points of matters that were discussed, there's no reference to how bad this was, to the gravity of the case. And in circumstances where it was said, the primary objective is to find the truth, but we're not actually going to have an inquiry. The best way of finding the truth is to review papers which don't contain the truth. Which is why we say, if that letter is taken at face value as representing the reasoning of the Secretary of State and the Prime Minister, both of them were, both of them misapprehended the facts so completely that it must be regarded as vitiating the decision.
Well, that's coming close to a rationality decision.
If the test were rationality, which we say it's not, then we would meet that threshold in our submission.
Yes, I mean, it's, again, I think the case is sort of simple. I mean, given that it was the big one, and everyone appreciated it was the big one, and given that Judge Corey had said the only way you can get at the truth is by a public inquiry, then you say it's very difficult to understand the view being taken that a public inquiry wasn't needed. I mean, whether that's rationality or whatever it is.
Means there has to be some
not good enough.
So completely compelling public interest factor to justify reneging on the promise that it's difficult to see how there is such a factor. There's none identified here, except by reference to government policy, and we don't want any more open-ended inquiries, and it'll be costly and it would take time.
This submission proceeds on the basis that all the information had been made available to the previous inquiries and there was nothing more in the documents, doesn't it? You're saying they said that it could be done on the documents, but the documents didn't contain the answer. So what do you make of the sentence, some of the evidence available only internally?
Well, I assume that's material that was available in government papers that might have been seen, should have been seen by Judge Corey. Indicated this internally as opposed to material that had been published or was in the public domain in some way.
If it wasn't, it undermines your submission. Means there was more documentation they knew of.
Well, we know that there was more documentation.
We do.
Because Geraldine Finucane says there was new and significant information that wasn't available to Judge Corey and Stevens.
Maybe I've misunderstood your submission then. Because it proceeds upon
More
the
likely
basis
that I misunderstood your
that they knew
question.
there was nothing else available in documents. Because, therefore, there could be no answer coming from the documents.
Yes, well, the understanding of the decision makers at the material time was that there wasn't anything else. I'm giving the decision makers the benefit of the doubt. I'm assuming that they did not appreciate that there was new and significant information that was going to be made available or obtained in some way by Sir Desmond de Silva that hadn't been previously made available to Judge Corey.
Well, there is a danger, I think, of being distracted by a discussion about whether the documents all contain the relevant information. As I've understood your submission, the essence of it is that civil servants had laid out in plain language for those who were responsible for taking the decision about this, the particular considerations that they had to attend to, and that there is no evidence in the contemporaneous documents that those considerations were taken into account.
That's essentially the submission. Obviously, there were elements of the factors such as cost that featured in the discussion, but the 6 public interest factors weren't addressed. But of course, the real reason why the answers aren't in the files is that there were the agent handler, for example, Nelson's agent handler,
I'd never made a statement
to cooperate, hadn't made any statement, hadn't been interviewed, hadn't said anything about what had taken place, so that even if there was going to be new and significant information in documents, it would never have constituted the kind of material that would have allowed the truth to emerge. The truth could only emerge, as had been said by Judge Corey and others, by having an inquiry at which the normal rules of evidence apply and there are powers of compulsion so that people are required to attend, subject obviously to any medical issues that may make it impossible for them to attend. But it was the absence of such an investigation or inquiry to date that made it impossible to find the truth. And it was quite clear from the papers apparently that the truth wasn't there, or the full truth wasn't there. And then just continuing briefly with Mr. Martin's note on the last page of his note, paragraph 6 is reference to the Ministry of Defence being in denial about the case and refusing to accept Stephen's conclusions on collusion. But at paragraph 7, the more prevalent view of the NIO and most others in government familiar with the detail is that the Finucane case is something of a horror story for the security forces. And then at Appendix 4, page 1058, MS 1378, and an email in the middle of the page. And this is important because it refers to the views of the Prime Minister. In the middle of the page, in this email from Mr. Martin to Mr. Haywood, as he then was, I've never spoken to the PM about it in person, but readouts I've had suggest the following approach. He, like virtually everyone else outside the MOD, shares the view that this was an awful case and as bad as it gets, and far worse than any post-9/11 allegation. And all of this, in our respectful submission, explains Sir Jeremy Haywood's reaction when he heard, apparently for the first time, that the Prime Minister was entertaining the notion of reneging on this commitment. And this can be seen on the next page, Appendix 4, page 1059, MS 1379, middle of the page, in an email. Does the Prime Minister seriously think that it is right to renege on the previous government's clear commitment to hold a full judicial inquiry? This was a dark moment in the country's history, far worse than anything that was alleged in Iraq, Afghan. I cannot really think of any argument to defend not having a proper inquiry. And that essentially sums up our case on the facts of this.
But I mean, those emails actually set it out very clearly. On the one hand, what the advisor is saying, isn't there some alternative to a long, costly inquiry to get at the result? We want a Savile moment without the 13 years.
Yes.
And then on the other side, Mr. Haywood is very clearly putting the point which you're putting.
Yes.
So, I mean, the debate was clearly going on. It's just a question of whether the decision is one they've made in the proper way.
Obviously there was some further discussion in this string of emails, and as the court will see at the top of page 1058, MS 1378, Jeremy Haywood replies to the reply that he had received and says, well, this makes a much stronger case than the papers for the meeting, and I was not involved before, but I do worry about the breach of trust and fear that we will get driven to the full inquiry if the family are dead set in one. So, although he gives the impression of softening his tone about his opposition to this, his instinctive reaction, in our respectful admission, is the correct reaction. That it's just inconceivable, unconscionable that there should be no inquiry in this case, which is, in the Prime Minister's view, apparently, an awful case and as bad as it gets. There are only so many ways in which I can say the same thing, that this is the worst case imaginable, according to the officials, and therefore, by definition, should have had an inquiry in circumstances where the full facts weren't known. Now, the court will know that all the other public inquiries that were recommended by Judge Corey went ahead. This one was stopped, even though arguably it was the one that was the most needed, and certainly where the public concern was the greatest and the issues were the most grave. So the respondents haven't satisfactorily identified what the public interest factors were that warranted their own conclusion. Still less explained how those factors, whatever they might have been exactly, were so compelling as to override the requirement to comply with the undertaking that had been given for the reasons that we've specified. In any event, we say this decision could never have been properly justified, given the gravity of this particular case. And insofar as it may be considered by any members of the court as somehow an inquiry may not have been productive because witnesses weren't available anymore, or there were other problems of that kind, there's no evidence to that effect. It's hinted at, suggested in the submissions, but it's not correct. There is evidence in the papers, specifically at Appendix 4, page 1043, MS 1363, that quotes, many of the witnesses on the government side are still alive, unquotes. And as Lord Stein said in Ree McCarr, you would expect evidence if there's some problem of that kind. If witnesses aren't available, you would expect evidence to that effect, and there is none. The third heading under which we propose to make submissions today, ladies and lords, is Article 2. First of all, it's our contention that Article 2 applies for the reasons accepted by the High Court and the Court of Appeal. What I propose to do is, first of all, rely on the written submissions we've already made, by and large, and on the reasoning of the High Court and the Court of Appeal, but I think it probably is important to conduct a brief review of three cases, just to reinforce the point insofar as the Court may entertain any doubt about whether Article 2 applies before we get to the second issue as to what is necessary to comply with Article 2. The three cases are McCaughey, Yanovich and Caillou. I'm going to deal first of all with McCaughey. That is in the first volume of authorities, tab 4. I know that some members of this court will be particularly familiar with this, and I apologise in advance for labelling points that may be already present to their minds. But,
reviving unhappy memories, I think. Intellectual difficulties of the argument.
There were those who were not here, and they'll benefit from your
I
exposition.
hope so, Lord. Well, McCaughey was a case from Northern Ireland where an inquest had been ordered into a death that had occurred before the Human Rights Act came into force. So the issue arose as to whether or not Article 2 would apply, and bearing in mind that in the background that McCarr had been decided by the Supreme Court to the effect that the Human Rights Act is not retrospective, and therefore any of the deaths occurring before 2000 will not attract the intervention or protection of the Convention. But in the head note at the first page of this report,
MS, please.
this is MS 3033.
Thank you.
Held allowing the appeal that the decision of the European Court, that's the decision in the case of Shilley, SH, I'm not sure if I...
It is
Shilley.
Shilley. It is Shilley.
Held allowing the appeal that the decision of the European Court had extended the effect of Article 2 of the Convention so that it now imposed a freestanding and autonomous procedural obligation, sometimes called a detachable procedural obligation, in relation to the investigation of a death which could arise where the death had preceded the court's assumption of jurisdiction, if a significant proportion of the procedural steps which Article 2 would require took place after that date. Now, I'm reading this and emphasising the words procedural steps because of the submission made by the respondents to the effect that somehow this case of McCaughey really only applies to the very narrow circumstances of an inquest, not even any other inquiry, but an inquest having been ordered. But it's clear even from the head note that what the court was concerned with was procedural steps, an example of which was an inquest in that particular case. And we say it was not limited to inquests. Now then, if I could turn to paragraph 48 in the judgment of Lord Phillips. This is MS 3054. He also was referring more generally to procedural steps. This by reference to the Shilley decision. This leads me directly to my next conclusion. The procedural acts and or omissions referred to paragraph 162 of Shilley relate to specific incidents of a particular process or procedure. Then there's reference to this genuine connection. As 50, again, he's referring to the procedural steps and says towards the bottom of the page, there's no temporal restriction on the obligation other than that the procedural steps take place after the Convention has come into force. At the top of the page, he refers also that thus if a state decides to carry out those procedural steps long after the date of the death, they must have the attributes that Article 2 requires. So he was referring to procedural steps, of which an inquest, as it happened in that particular case, was an example. Likewise, in paragraph 52, the references to procedural steps. Paragraph 61, at page MS 3057. What difference has Shilley made? Refers to, again, the need for procedural steps. Refers to it as being a new freestanding obligation that arises by reason of current events. And the relevant event in these appeals is the fact that the coroner to hold an inquest. That doesn't mean that the court was narrowing their decision to the scope of an inquest only. They were just saying that the relevant event in this particular case is an inquest, but it's in the context that it's relevant steps, procedural steps that are an issue. And it was in that case that it was decided the mirror principle should prevail. 62. On the procedural meaning, the provisions of the HRA, they apply to any obligation that currently arises under Article 2. These appeals are concerned with such an obligation, specifically an inquest, but not limited to an inquest. In paragraph 77, Lord Hope dealt with the matter, and again he, over the page MS 3062, refers to holding of inquests being a procedural act, obviously linking it with the reference to procedural steps in Shelley. And then at paragraph 89 in my Lady Baroness Hale's judgment, the serious criticism of the Shelley decision that leaves so much uncertainty about when the investigative duty continues. Excuse me. However, I also agree with Lord Phillips, with him in one respect. They are quite clear. These are the words of Shelley. That is, in his words, where the event occurred and an investigation was initiated before the entry into force of the Convention, but a significant part of that investigation was only carried out after that date. Of course, that, Lady Hale said, that is this case, and that is this case too, because there was no serious investigation in this case at all until Stevens 3, most of which took place post-Human Rights Act. And continuing at the end of paragraph 89, but for a variety of reasons, things have proceeded very slowly since then, and a significant part of the investigation, again, not limited to inquest, investigation in particular, in particular, makes it even clearer, in particular, the inquest has still to take place. So this is not limited to inquests.
So what's the point you're getting from this, Mr. MacDonald? I mean, this is obviously a different situation because we had the Human Rights Act. I mean, is the point that here, once you've decided to hold the De Silva inquiry, then it's got to comply with Article 2?
Well, sorry, I'm anticipating the point, well, not anticipating, addressing the point raised by the respondent that somehow McCaughey only applies to this very narrow situation where an inquest had been ordered. And it doesn't apply more generally to the situation where, as in the present case, an investigation has actually taken place. Well, most of the investigation has taken place after the Human Rights Act came into force in 2000. So that specifically, Article 2 requirements applied to the Stevens investigation and to any other investigation or review of the facts.
Yes, you're saying Stevens 3 and De Silva had to comply with Article 2. They were post-HRA events.
Yes.
And they were investigations.
Yes. Yes. Of course, the purpose of Corey, which is another one of the reviews that was taking place during this period, the purpose of Corey was to say whether or not an inquiry was necessary. So it did comply with Article 2 in the sense that it was indicating, for all these reasons, the next step is an inquiry, a proper inquiry with powers of compulsion. So then, further at paragraph 93, letter C, this is MS 3066, just after letter C, the one case which doesn't quite fit into Judge Lawrenson's formulas where there is a death before the relevant date and the decision to hold an inquest or other inquiry is taken after that date. To my mind, that would still fit into the criterion of a significant proportion of procedural steps required by this provision will have been carried out after the critical date. In other words, if there's now to be an inquiry into a death for which the state may bear some responsibility under Article 2, it should be conducted in an Article 2 compliant way. And of course, it will be remembered that the state here, interestingly, some 3 months after the McCaughey decision was handed down, decided to reverse the decision which had previously made to the effect that an inquiry should take place. So that a decision had been made that there should be an inquiry. And the effect of McCaughey, albeit retrospectively, partly retrospectively, was that inquiry had to comply with Article 2. And as of the date of the McCaughey decision, there hadn't been any decision to reverse the decision to have an inquiry. So as of the date of the McCaughey decision, it was expressly the case that the inquiry that was scheduled to take place, or due to take place, should be compliant with Article 2. Then paragraph 119 of the judgment of my Lord Kerr, MS 3072. My Lord Kerr then sought to distill some of the principles from these cases and set out a number of matters from the bottom of page 3072, MS 3072. Refers to the need for a connection, and in particular Roman numerals 3, where much of the investigation into the death occurs after the critical date. The connection is present, and that was a particular subparagraph relied upon by the High Court Judge, Mr. Justice Stevens, because this was quite clearly a case where much of the investigation into the death had occurred after the critical date, and therefore the convention applied. And Lord Dyson, likewise, at paragraph 129 and 130, I don't need to read all that, refers to investigations and procedural steps rather than limiting it to inquests. 131 as well, investigation. 139, procedural steps. Sorry if I'm flitting through this quickly, but just to save time. That's McCaughey. So, absolutely clear. Then, Yanovich, which came after McCaughey, volume 4, tab 49. MS 4535. If I can move directly to paragraph 142 at MS 4580. Refers to procedural acts and omissions in the post-entry into force period. And the Court reiterates at the outset the procedural obligation to investigate is not a procedure of redress for an alleged violation of the right to life.
So which paragraph are you reading from?
142, my Lord.
Yeah, thank you very much.
MS 4580.
Yeah.
Where it said that the last sentence there, accordingly, the Court's temporal jurisdiction extends to those procedural acts and omissions which took place or ought to have taken place in the period after the entry into force of the Convention in respect of the respondent government. And I'll just read paragraph 143 because it seems to have given rise to some misunderstanding since then. The Court further considers that the reference to procedural acts must be understood in the sense inherent in the procedural obligation under Article 2, namely acts undertaken in the framework of criminal, civil, administrative or disciplinary proceedings which are capable of leading to the identification and punishment of those responsible or to an award of compensation to the injured party, which is the present case, the intention being that it should lead to the identification and eventual punishment of those responsible. This definition operates to the exclusion of other types of inquiries that may be carried out for other purposes, such as establishing an historical truth. For example, the KU case, where the only object of the applicants was to establish an historical truth rather than to establish the identification and punishment of those responsible. Then paragraph 145 deals with the genuine connection test. 146 refers to the time factor being the first and most crucial indicator of the genuine nature of the connection. It notes, as it previously did in the Chamber judgment, that the lapse of time between the triggering event and the critical date must remain reasonably short if it is to comply with the genuine connection standard. Although there are no apparent legal criteria by which the absolute limit on the duration of that period may be defined, it should not exceed 10 years. I'm just pausing there. It's clear from within that sentence itself that this means it shouldn't normally exceed 10 years. It's clear that it's being recognised by the Court. There's no absolute limit. And in fact, there aren't even any clear criteria which define the length of the period which could constitute a reasonable connection. The Court itself has, in the subsequent case, we've dealt with this in the submissions, but in simple, short terms, the Court itself has referred to this as meaning normally 10 years. That's in the Mokanu case, and there's another case against Serbia, where the period was 13 years and it was still caught by, it was still regarded as having a genuine connection. So this 10 years is not an absolute limit, and the court never suggested it was an absolute limit. And as we'll see shortly, in the KU case, Lord Newburger recognised that this simply means normally 10 years. So there's no 10-year limit. It's a guide. 147, the duration of the time period between the triggering event and the critical date is, however, not decisive in itself for determining whether the connection was a genuine connection. As the second sentence of the paragraph in Shilley indicates, the connection will be established if much of the investigation into the death took place or ought to have taken place in the period following the entry into force of the Convention. And that's where Roman numerals subparagraph 3 of Lord Kerr's judgment comes from. This includes the conduct of proceedings for determining the cause of death and holding those responsible to account, as well as the undertaking of a significant proportion of the procedural steps that were decisive for the course of the investigation. 148, having regard to the above, the court finds that for a genuine connection to be established, both criteria must be satisfied. First of all, the period of time between the death as a triggering event and the entry into force of the Convention must have been reasonably short. Of course, what's reasonably short depends on circumstances. For example, whether the government may have been blocking an investigation for all that time. And secondly, a major part of the investigation must have been carried out or ought to have been carried out after the entry into force, which is the present case. And then there's the Convention values test from paragraph 149 onwards, which applies even when those factors don't operate. The court further accepted that there may be extraordinary situations which do not satisfy the genuine connection standard, as outlined above, but where the need to ensure the real and effective protection of the guarantees and the underlying values of the Convention would constitute a sufficient basis for recognising the existence of a connection. These would operate to the exception of the general rule of the genuine connection test, and the test that's applied is the Convention values test is set out at paragraph 150, where it was said that the Grand Chamber considers the reference to the underlying values of the Convention to mean that the required connection may be found to exist if the triggering event was of a larger dimension than an ordinary criminal offence and amounted to the negation of the very foundations of the Convention, which is this case, as recognised by the government itself and their officials. That's why Mr. Justice Stevens in the High Court took the view that, well, first of all, that there was a genuine connection, applying the proper criteria. But even if he was wrong on that, this case met the Convention values test. That's Yanovich. Then KU at Volume 3 of the authorities, tab yes, tab 33, right. This is classically a case about appellants trying to establish an historic truth rather than an inquiry involving a framework which could lead to the identification and punishment of those responsible. But more importantly, for present purposes, this is about the critical date. It's not actually about the genuine connection at all, in any real sense. It's about establishing the critical date concerning the coming into force effectively of the Convention, and whether it was,
or indeed the Convention itself.
Yes.
Because the relevant events took place before the Convention was even drafted and signed.
I know that this is an even more recent case, so I'm sure the court's familiar with the background, so I don't propose to dwell on much of this at all.
Well, some of it I'm not sure about.
Well,
Some of us have very clear recollections of it. But
sure. Well, it obviously concerned an event in 1948
yes.
when it was alleged that a British Army patrol had shot and killed 24 civilians in Malaya, as it then was, and there was an application for an investigation into this episode. And the question was whether a genuine connection existed. That was initially the issue, whether there was a genuine connection, but then it became apparent, I think probably only on appeal, actually, that the critical date was not in the respondent's submission, 1953, when the convention came into force, but 1966, when the right of an individual petition became effective. And that became really the focus of the debate and the basis upon which the case was ultimately resolved. And
What's the point for our purposes?
I mean,
I may be
this is relied upon by the respondents in support of their suggestion that somehow Article 2 doesn't apply here, and Article 2 is limited to these McCaughey's limited to the very narrow circumstances of where an inquest, nothing else, an inquest has been ordered by the estate. And we are referring to this to make it clear that, well, first of all, Kay didn't actually decide anything about that, didn't decide anything about domestic law, strictly speaking. It was all about the critical date when the convention had effect. Was it when it was created in the first place, or was it when the individual right of petition became available? So everything else is older. But in any event, during the course of KU, there were certain dicta which support our submission, such as the reference by Lord Newburgh to the fact that McCaughey applied to an inquiry generally, as opposed to just an inquest. But and also there's reference by my Lady Baroness Hale to the historic truth point. And I'm just referring to this just to show the context in which that was said, which was a case about establishing an historic truth, and wasn't intended to be any more than that in our respectful submission. So at paragraph 71 of Lord Newburgh's judgment at MS 3948, there's a reference to Yanovich and the principles apply there. And this is also important, my Lord, because this postdates McCaughey, and it deals with the Yanovich case, because there's a suggestion that somehow Yanovich undermines McCaughey or invalidates its conclusions, or would cause this court to revisit McCaughey, to restrict its ambit in some way. And it's important to recognise that in KU, which post-dated Yanovich and took Yanovich into account, there's no suggestion to that effect at all. So paragraph 70 and 71, there's reference to the Yanovich case. What's said just under letter D is that the issue in this case, which requires consideration of judgments other than Yanovich, is whether the critical date is the date on which the state in question signed up to the convention, or the date on which that state gave its citizens the right to petition the Strasbourg court in relation to any alleged infringement of their convention rights. So this is very much about the convention rather than the Human Rights Act, in circumstances where the mirror principle doesn't apply, because it was a very particular aspect of the convention that was an issue, namely whether we're talking about when it came to exist in 1953, or when the right of an individual petition arose in 1966. The relevance of that, of course, being that there could be no genuine connection maybe between an event in 1948, or there's less likelihood of a genuine connection ever being established if the connection was between 1948 and 1966, as opposed to 1948 and 1953. And then at paragraph 81, 76, he turns to the second criterion, and at 77 refers to the critical date and the importance of establishing what the critical date is. And at 87, paragraph 87, MS 3951, this is still in the judgment of Lord Neuberger. Quite apart from the Strasbourg jurisprudence, I consider that the respondent's contention as to the critical date accords better with principle. The rule that one cannot, at least normally, go back more than 10 years relates to the jurisdiction of the Strasbourg court. And we refer to that because it's taken as granted so obviously the case that this is normally, that it doesn't require any great consideration. And I have to refer to that because of the fact that the respondents are suggesting that there's an absolute 10-year limit. Because the significance of that in this case is that Pat Finucane was shot in 1989, 11 years before the Human Rights Act came into force. And the suggestion is that it doesn't meet the 10-year rule. There is no 10-year rule other than a rule of thumb from which there can be exceptions. And then at paragraph 94, Lord Neuberger's judgment at MS 3953. In the light of the Grand Chamber judgment in Chile, some members of this court adopted a somewhat modified position in the subsequent case of McCaughey. That is, they modified the retrospectivity rule decided by the Supreme Court, or the House of Lords rather, in McCurr. In that case, by a majority of 6-1, the Supreme Court held that at least where there had been a decision to hold an inquest into a death which had occurred before October 2000, the 1998 Act could be invoked to require the inquest to comply in all procedural aspects with the requirements of the Convention. And I can see no reason why the same reasoning would not apply where the decision was to hold an inquiry into a death which had occurred before the 2nd of October 2000, or indeed an investigation. And of course, that's exactly what happened here. The government decided in 2004 to hold an inquiry into this death, and therefore, as we now know from McCaughey, there was an obligation all along from that point to hold an inquiry that was compatible with Article 2. And the government ought to have known that that was the case by the time the decision was made not to have an inquiry at all, because McCaughey was decided some 3 months before the decision was taken to reverse the inquiry. But whether or not they were aware of it, the legal position was this was an inquiry that had to be conducted, and conducted in accordance with Article 2. And in any event, there had also been an investigation, including particularly the Stevens investigation, which ought to have complied with Article 2, being an investigation that happened mostly after 2000. Of course, that police investigation could not have complied with Article 2. And then at paragraph 273, Lord Kerr made some remarks in relation to proportionality, which of course we say is the test here in relation to legitimate expectation. Could I have a moment? This is at MS 3997. I just refer to this because I'm conscious there's an issue about the test to be applied and legitimate expectation and whether it's proportionality, whether it's rationality, and there's a query about whether it may matter ultimately at the end of the day, whether that may be an arid debate in circumstances where really it all depends on the context, as Lord Stein might have said. And the facts of the case steer the court towards the conclusion that it has to be a close, anxious examination or scrutiny of the hard-edged scrutiny of the matter. So whatever the test is called, whatever the approach is characterised as, it's a detailed, close, anxious examination of the facts, and not trumped by any suggestion of macro-political factors. But in paragraph 273, it should also be understood that the difference between a rationality challenge and one based on proportionality is not, at least on a hypothetical level, as stark as it's sometimes portrayed, and there's reference to what Lord Mance said in the Kennedy case, which was essentially that subject to the weight to be given to a primary decision maker's findings of fact, the court must be entitled to subject an administrative decision to the more rigorous examination to ensure that it is in no way flawed according to the gravity of the issue. And Lord Mance developed that in relation to proportionality and reasonableness reviews. Both involve considerations of weight and balance with the intensity of the scrutiny and the weight to be given to any primary decision maker's view, depending on the context. Likewise, 275, another passage from Lord Mance's judgment in the FAM case, where context will determine the appropriate intensity of review, the last sentence there. And then, and there's some discussion about the heightened or anxious scrutiny cases, starting from Daly. But if I pass over that then to paragraph 300, where my Lady Hale said that first is whether what the claimants want falls within the procedural obligation in Article 2 at all. In the Yanovich case, the court observed that the procedural acts which took place or ought to have taken place after the entry into force referred to, and then it's set out there. And over the page, and this is why this is important to understand the context in which this was said, the claimants do indeed seek reparation, but this is not by way of an ordinary civil action, which would have been time-barred a very long time ago, and not from the actual perpetrators. And it is now quite unrealistic to expect that anyone could be prosecuted for their part in what took place. What the claimants really and rightly want is a proper, full and fair inquiry, which will establish the truth, so far as it's possible to do so, vindicate their deceased relatives, and lead to a retraction of the official account of what took place. Of course, we in this case want a lot more than that. We want accountability, individual accountability of culprits who are identified and, in due course, prosecuted if the evidence would support a prosecution. So this is not the present case is not an historical truth case. And it was in that context of the facts of KU that my Lady Hill said in Yanovich, the court went on to say that this definition operates to the exclusion of other types of inquiries, such as establishing a historical truth.
It would have been a lot simpler if everybody had agreed with me on that point, wouldn't it?
It would have been.
Nobody would have had to go through all the agony of working out
Well, we all know what
how to get over the bridges. Yes.
We all know what your ladyship must have meant, because in McCaughey, your ladyship referred expressly to inquests as being within the ambit of Article 2, obviously, and in fact, been identified, as the court knows, in Middleton by Lord Bingham, as the inquest has been identified as the means by which the state discharges its Article 2 obligations in the absence of any other particular inquiry. I think perhaps the last case I want to refer to briefly in this section is the Edwards case, which can be found in volume 4. at tab 47. I'm only referring to this very briefly as an illustration of what is required in an Article 2 type inquiry. This was a case where...
MS?
Sorry, this is MS 4477, Edwards v UK. This was a case where the applicant's son had died following an attack by a fellow prisoner. There were medical health issues involved in the case for both prisoners, in fact. But at paragraph 65, MS 4493 onwards, the court deals with the procedural obligation to carry out effective investigations, and in particular, it dealt with the various shortcomings of the investigation. And at paragraph 78, MS 4495, it referred to the lack of power to compel witnesses. The inquiry had no power to compel witnesses, and as a result, 2 prison officers declined to attend. And there's some reference to the evidence of that prisoner. And then 79, the court finds that the lack of compulsion of witnesses who are either eyewitnesses or have material evidence related to the circumstances of a death must be regarded as diminishing the effectiveness of the inquiry as an investigative mechanism. In this case, as in the Northern Irish cases referred to above, it detracted from its capacity to establish the facts relevant to death and thereby to achieve one of the purposes required by Article 2. And then paragraph 82 in the same page, the inquiry sat in private. During its hearing of evidence and witnesses, its report was made public. And over the page, there's referenced in the same paragraph, in paragraph 83, MS 4498, there's reference to the need for the widest exposure possible. And 84 points out that the parents were only able to attend the days of the inquiry when they were giving evidence themselves and weren't represented. The conclusion at 87 is that the court finds that the lack of power to compel witnesses and the private character of the proceedings from which the applicants were excluded failed to comply with the requirements of Article 2. Now, I see that it's...
Well, that sounds like quite a good point at which to pause, does it not, Mr. McDonald? I'd just like to raise one point with you. It's common practice in this court for the clients to sit in the row behind you so that they've got something on which to write, and if they need to tug your gown metaphorically, they can do so. Now, obviously, if Mrs. Finucane would prefer to sit where she is sitting, that is fine. But if she prefer to sit rather closer to the action, that will be the normal practice in this court.
Very much obliged.
I will leave it to you to decide that over the short adjournment. And we'll look forward to hearing from you further at 2 o'clock.
Thank you.